Racism is wrong. At least that's what I've been told my entire life. But if racism is wrong, why do so many people demand we make decisions based on race? Is an election fair if the people who vote are racially chosen? If it was wrong for people to be denied the representation because of their race, why is it okay for them to deny representation to others for the same reason? Is choosing representation based on race wrong? That's the question presented in the Supreme Court case Louisiana versus CALLAIS, which we'll look at next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. Glad you could join me today. Racism has been an issue in this country, well, for as long as I've been around. It goes all the way back in the 1960s. It goes all the way back to the founding and slavery. And to me, the problem is not simply that we have had racism. That's a historical fact. It's the fact that we keep perpetuating it. Again, I'm going to look at this case in a minute, but if you want to find out more, if you want to follow along, if you want to check my work, go to constitutionstudy.com, find this article. You'll find all my links to all my sources so you can double check my work. Now, I'll talk more about the website and ways you can support the work that we're doing here at the end of the episode. But for now, let's get into this question of racist gerrymandering and what Louisiana was doing. Gerrymandering, or drawing a district to gain a political advantage, is nothing new in America. The term is derived from the name of Governor Elbridge Gerry of Massachusetts, whose administration enacted a law in 1812 defining new state senatorial districts. The law consolidated the Federalist Party vote in a district and thus gave disproportionate representation to Democratic Republicans. The outline of one of these districts was thought to resemble a salamander, a satirical cartoon by Elkanah Tisdale that appeared in the Boston Gazette graphically transformed the district into the famous animal, the Gerrymander, fixing the term in the popular imagination. Now, more recently, states have used race to draw district maps, but still with a political advantage in mind. Louisiana's latest congressional map has been challenged in court as being unconstitutional. These cases concern whether Louisiana's new congressional map is an unconstitutional racial gerrymander. In 2022, after the state redrew its congressional district, a federal judge in Robinson versus Ardoin held that the 2022 map likely violated Section 2 of the Voting Rights Act of 1965, Title 52, Section 10301 of the United States Code, because it did not include an additional majority black district. After the 2020 census, Louisiana, like other states, redrew their congressional districts. Technically, Louisiana did not have to redraw their maps, since the state had the same number of members in the House of Representatives as it had under the previous census, but they redrew their maps anyway, and a federal judge decided that they violated Section 2 of the Voting Rights Act of 1965. Now, subsection A states that no citizen in the United States can have their right to vote denied or abridged because of their race. The question really comes in subsection B, which reads, a violation of subsection A is established if, based on the totality of circumstances, it is shown that the political process leading to the nomination or election in the state or political subdivisions are not equally open to participation by members of classes of citizens protected by subsection A, in that its members have less opportunity than other members of the electorate to participate in the electoral process and to elect representatives of their choice. What does it mean to have less opportunity to elect representatives of their choice? According to the judge in Robinson v. Ardoin, that meant having a congressional district made up of a majority of black citizens. The judge ordered Louisiana to draw a new map. But when the state drew a new map, SB 8, that contained such a district, the new map was challenged as a racial gerrymander. A three-judge court in CALLAIS versus Laundrie held that SB 8 violated the Equal Protection Clause of the 14th Amendment, and the state appealed to this court. Sounds to me like damned if you do, damned if you don't. Don't include a majority black district, and one court says no. Include a majority black district, and another court says no. What was Louisiana to do? They appealed to the Supreme Court. The parties originally briefed and argued this suit last term, and their arguments at that time highlighted problems in the existing body of Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. In other words, the courts had created problems based on how they decided cases involving racial discrimination in the Voting Rights Act. The first problem was that courts treated racial discrimination differently if it involved gerrymandering. The court said the only way to trigger strict scrutiny, the highest level of effort needed for governments to infringe on your rights, is if the state predominantly based its decision on race. Well, the state doesn't make decisions. Their representatives and their legislatures do. Just how does a court determine what the legislatures were thinking when they had their maps drawn and when they voted on them? That was just one problem with the court's precedent. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. In other words, does the Voting Rights Act require states to predominantly use race when laying out their congressional maps? Wouldn't that automatically trigger strict scrutiny? For over 30 years, the court has simply assumed, for the sake of argument, that the answer is yes. These and other problems convinced the court that the time had come to resolve whether compliance with the Voting Rights Act indeed provided a compelling reason for race-based districting. For over 30 years, the Supreme Court has simply rubber-stamped the idea that racially based gerrymandering was okay because the Voting Rights Act said so. But as Justice Alito wrote in the majority opinion, the court decided it was time to resolve whether or not that was true. Are states allowed to discriminate based on race? According to the court, the answer is yes. The Constitution almost never permits a state to discriminate on the basis of race, and such discrimination triggers strict scrutiny. The court's precedents have defined only two compelling interests that can satisfy strict scrutiny: avoiding imminent and serious risks to human safety in prisons and remediating specific identified instances of past discrimination that violated the Constitution or a statute. So apparently the states can use racial discrimination, but only to avoid safety risks in prison or to remediate specific instances of past discrimination, which points to another question. The question presented is whether compliance with Section 2 of the Voting Rights Act should be added to this very short list of compelling interests. The court now holds that compliance with Section 2, as properly construed, can provide such an interest. A proper interpretation of Section 2 requires examining the statutory text to understand what it demands with respect to drawing legislative districts. The Section 2 of the Voting Rights Act identify specific instances of past discrimination? No. So the Supreme Court plans to decide how hard governments must work to infringe on your rights. There's a twist that I did not see the court deal with, specifically that a majority black congressional district must deny to at least one group the opportunity to elect representatives of their choice, which is exactly what Justice Kagan argued for in her dissent. Now, to justify her position, Justice Kagan came up with a rather strange straw man for her argument. Consider the story of a hypothetical congressional district in a hypothetical state, subjected to a redistricting scheme. The example is admittedly stylized, but it is in essence simulates the dispute before us and clarifies the immense issues at stake. The district, let's say, is a single county in the shape of a near-perfect circle sitting in the middle of a rectangular state. Okay, let's imagine this hypothetical district consisting of a single county. Its shape really is irrelevant. This county, like all others, is in a state that has a history. The state is one with a long history of virulent racial discrimination, and its many effects, including a residential segregation and political division, remain significant even today. A history of virulent racial discrimination. How long ago? Justice Kagan claims it remains significant today, but she's creating the hypothetical in an attempt to promote her agenda. The population of the Circle District is 90% black. The rest of the state, divided into 5 surrounding districts, is 90% white. And voting through all those districts are racially polarized. Black residents vote heavily for Democratic candidates, while white residents vote heavily for Republicans. The Circle District thus enables the state's black community to elect a representative of its choice whom no neighboring community would put in office. Again, a perfectly crafted straw man, based not in any practical reality, but meant to promote an agenda, along with what comes next. But that arrangement in this not-so-hypothetical is not to last. the state legislature decides to eliminate the circle district, slicing it in 6 pie pieces and allocating 1 each to 6 new, still solidly white congressional districts. The state's black voters are now widely dispersed and, unlike the state's white voters, lack any ability to elect a representative of their choice. Election after election, black citizens' votes are, by every practical measure, wasted. Now, in Justice Kagan's crafted straw man, her own racial bias shows through. Blacks vote heavily Democrats, while whites vote for Republicans. This mythical state apparently has no significant Hispanic or Asian population. And while the stereotype of voting patterns may have some historic basis, they also have been changing over time. What is Kagan's conclusion from this thought exercise? That is racial vote dilution in its most classic form. A minority community that is cohesive in its geography and politics alike, and that faces continued adversity from racial division, is split, cracked is the usual term, so that it loses all its electoral influence. This straw man that Justice Kagan comes up with has one fatal flaw. While the straw man may be an excellent example of racial vote dilution, it in no way resembles what Louisiana did with their congressional map. And because that is so, Congress and the Voting Rights Act made the practice illegal. Section 2 of the Act guarantees that members of every racial group have an equal opportunity to elect representatives of their choice. The Voting Rights Act may have claimed to make Justice Kagan's straw man illegal, but she seems to forget that the Constitution of the United States supersedes federal law. The Article 6, Clause 2 of the Constitution states, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." So when the 15th Amendment says citizens shall not have their right to vote denied or abridged for reason of race, wouldn't that include denying a majority of citizens their chosen representatives in favor of the minority's choice? Even after the 15th Amendment banned racial discrimination in voting, state officials routinely deprived African Americans of their voting rights. There was a seemingly boundless array of mechanisms, most of them facially race neutral, and among them the drawing of district lines. States either prevented black citizens from casting ballots or ensured that their votes would count for next to nothing. And those cases of state officials depriving people of their right to vote due to their race have been prosecuted, or at least the ones we know about. And while the Voting Rights Act has helped enforce the 15th Amendment's prohibition on denying or abridging the right to vote, does it guarantee the desired outcome? The Voting Rights Act was meant as a corrective, and when this court construed it too narrowly, insisting that a person suing under Section 2 had to prove discriminatory intent, Congress amended the law so that it turns solely on discriminatory effects. Under that revised version, a person has a good Section 2 claim if the challenged state action, in the totality of circumstances, results in an electoral system not equally open to members of his racial group, meaning the system gives those citizens less opportunity to participate in the political process and to elect representatives of their choice. Which brings to mind an interesting question. Is this obsession with gerrymandering a question of race or of political party? Because the United States doesn't have a black political party or a white political party. Yes, election outcomes have shown that majority black districts tend to vote for the Democratic Party. But then there are quite a few predominantly white districts that do so as well. So is the vote dilution racial or political? Is Justice Kagan attempting to justify the vote dilution of the Republican Party? And for 40 years now, this court has recognized that language to encompass districting decisions that, in the way illustrated above, result in vote dilution, the minimizing of minority voters' ability to elect their preferred candidates. In other words, fewer members from the House of Representatives from the Democratic Party. But no longer. Under the court's new view of Section 2, a state can, without legal consequences, systemically dilute minority citizens' voting power. Of course, the majority does not announce today holding that way. Its opinion is understated, even antiseptic. The majority claims only to be updating our Section 2 law as though through a few technical tweaks. But in fact, those updates eviscerate the law so that it will not remedy even the classic example of vote dilution given above. Except when the court looked at the outcome rather than the intent, the effect was to guarantee Democratic candidates an advantage by requiring gerrymandering based on race. Justice Kagan concluded, "I dissent. The Voting Rights Act is, or more accurately was, one of the most consequentially efficacious and amply justified exercises of federal legislative power in our nation's history. It was born of the literal blood of Union soldiers and civil rights marchers. It ushered an awe-inspiring change, bringing this nation closer to fulfilling the ideals of democracy and racial equality, and has been repeatedly and overwhelmingly reauthorized by the people's representatives in Congress. Only they have the right to say it is no longer needed, not the members of this court. I dissent, then, from the latest chapter in the majority's now compelling demolition of the Voting Rights Act. The problem isn't with the Voting Rights Act, but with the Supreme Court's requirement that a certain outcome be achieved. Now, what did the court conclude in this case? Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8, and that map is an unconstitutional racial gerrymander. See, contrary to what Justice Kagan said in her dissent, the Voting Rights Act does not require a state to set aside a certain number of congressional districts to be majority of minority voters. For that reason, Louisiana has no compelling interest in using race to create their congressional map, which means it was the judges in Robinson versus Ardoin who were wrong when they demanded that Louisiana do so. They did so by placing a flawed opinion of the Supreme Court above the actual supreme law of the land. The ridiculous straw man that Justice Kagan put forward shows just how racism is still alive and well in the federal government. It goes far beyond recognizing past voting habits, but assumes they are based on a person's race rather than how they were raised. If we want racism to stop, we must stop acting in a racist fashion. If Justice Kagan wants to make sure that members of the Democratic Party get more votes, she should just say so. I'm frequently disturbed by this reductionist idea that everything is about race. That we have to have a certain and a racial decision here and there. We must vote everything based on race. And the only reason I didn't get a Democrat or more Democrats in a state's representation is because of racism. And Justice Kagan just gave us a racist argument to promote the Democratic Party, which really shouldn't surprise one little bit. But there's more. Justice Kagan acted as if the only way to get Democrats elected was to have blacks vote for them. Does that sound like a racist argument to you? Now, I do understand the logic. Political parties want more representation. And they will apparently argue pretty much anything they think will get them more representation. But whatever happened to majority rules? They're talking about protecting minorities. And I understand minorities have rights, and they have the right to vote, and they have the right to participate. Do they have the right to win elections? That's really what Kagan is calling for, right? If we don't do this, if we don't give the minority a chance to win an electoral seat, then all is lost. But I thought the majority rule in our quote-unquote democracy, our republic. Doesn't the majority rule? Again, I understand both sides. I understand how this gerrymandering is used to suppress racial votes, but it's now being used to suppress other racial votes, just in the other direction. And not necessarily with a specific requirement of showing a specific racist past that they're trying to correct. It's actually promoting racism. I guess we're never going to get rid of racism in this country until we stop judging everything based on race. Now, if you'd like to find out more, if you'd like to ask questions or maybe comment on this episode, well, go to the website, constitutionstudy.com, and find the article, ask your question, make your comment. Of course, you can also ask questions by going to constitutionstudy.com/questions or just emailing questions@constitutionstudy.com. Both will get you a question asked, which you can either have answered directly via email, or if you'd like me to answer it on the radio program, well, just say so in the question, and I'll be more than happy to. There's a checkbox on the website, or you can just ask that I do so in the email. You can also support the work that we're doing here at the Constitution Study store. Just go to constitutionstudy.com/shop, and, well, anything you buy, the proceeds go to keeping the Constitution Study up and running. Nobody here takes a salary. Nobody here takes money out of this system. It's all about keeping the system up and running. By the way, if you just want to donate to the cause, there's a donation page. You can make a one-time or a recurring donation. All of it goes to keeping the Constitution Study up and running. All of it goes to help me do events with other people, where I can speak to other groups without charging them for it. It becomes a big deal when a group wants you to come in and speak at their event if you've got to charge money in order to do it. And if I don't get money, how do I pay for my travel and living and everything else? So every time I go to speak without having to charge somebody, part of it is people like you helping by donating to the cause. Of course, you can also support the work we're doing here with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. That's not why I joined them. I joined them because they take a portion of every dollar to support organizations like the Constitution Study that are fighting for your rights. Go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount. And when you pay your cell phone bill, guess what? You're helping support organizations just like the Constitution Study that are defending your rights. By the way, if you use the code Constitution at checkout, you get free activation. So join us today. They're going to patriotmobile.com/constitution, finding a plan and discount that works for you. And don't forget that code Constitution at checkout to get free activation. I also hope you'll come by the next time we get together and, hey, maybe bring a friend or two when we meet for the Constitution Study.